morning. Thank you for joining today's seminar, 2022 Real Estate Legal Updates with Paul Chang. My name is Jenny Ching. I am your 2022 Education Committee Chair. Just a quick reminder before we begin, all participants will be muted during the session, so please put all your questions in the chat box, and the presenter will answer them at the end of the session. And this session will be recorded, and you can find the video later on in the WSGBAR YouTube channel. So next, we will have Jeff introducing our speaker today. Jeff?
Thank you, Jenny. Good morning, everyone. My name is Jeff Wong from eXp Realty, your 2022 Education Committee Vice Chair. The Education Committee of the West San Gabriel Valley Realtors is happy to host today's topic, and we have the perfect guest speaker to give us a 2022 real estate legal update. Now, I have the great honor to introduce our amazing guest speaker, Attorney Paul P. Chang. Attorney Paul Chang is a senior partner and shareholder with PPRC Law, APC, an international law firm that Inc. 5000 listed as one of the fastest growing businesses in America. Paul has spent countless years helping us realtors with his extensive legal experience. His service career includes the following: Deputy City Attorney, Prosecutor Mediator with the City of Hesperia, City Council with Arcadia District 4 in 2020, Professor at Cal State University, past President-elect of the San Gabriel Chamber of Commerce and Arcadia Kiwanis Club. He is not only an esteemed member of our real estate and legal community, but the community at large. Paul has counseled in a variety of transaction and legal matters, including contract, landlord-tenant, land use, employment, franchise law, fraud, identity theft, business immigration, civil rights violation, products liability, trademarks violation, construction defect, and general tort. Without further ado, let's give a very warm welcome to our special guest speaker, Attorney Paul P. Chang. Paul, the floor is yours.
Oh, wow. Well, thank you so much for giving me the opportunity to come and give you the respect you deserve. My name is Paul Chang, and I am going to be giving 2022 real estate issues and updates for the best group in Southern California. I do want to say before I begin that I've been preparing for pretty intense city council stuff as well as a trial. And so I haven't lectured in a long time, and I've kind of not wanted to lecture to anybody. But when Pauline came to me and she told me it was this team, the West San Gabriel Valley Realtors, I couldn't say no. And so with that, I really hope that everybody realizes I am a little bit nervous, a little bit stressed, but totally appreciative to be with you today. So let's begin. So the first issue is always the disclaimer. This presentation is for educational purposes only. It is not legal advice, and really you can contact an attorney if you want specific legal advice. Yes, I am the Mayor Pro Tem for the City of Arcadia. No, I do not represent the City of Arcadia for purposes of this lecture. And the reason why that's important is because one of the things that I'm going to be discussing today, many of them come from the Arcadia agenda, and I'll explain. I think one of the benefits of being on City Council is I've really seen almost the practice of law in a vastly different way. And I think that the way I explain it to you is going to help you quite a bit. I do focus on 3 areas, although there was very detailed, but real estate, business, and labor compliance, those are the 3 areas I'm really good at. I have attorneys that are in different areas of law. You can be able to speak with them. For example, right now in the middle of COVID, evictions, both defense as well as prosecution of cases, I would recommend, although I'm going to be speaking about it, I would recommend another attorney at the firm. And I do have their names, Joseph Castro, as well as David Sheen. They would be really great. So the US has 2 different types of law. It's pretty obvious. One is criminal, one is civil. And civil laws break down into torts and contract. The reason why this chart is very important is because Before we begin talking about real estate laws, you do have to understand that some real estate laws also refer to torts. So what's a tort? Civil laws, again, are broken into contract, non-contract. So we talked about US laws, and US laws are civil and criminal. In the civil context, we have contracts and no contracts. So in the no contract area of law, that is called a tort. And a tort is split into three different types. One is an intentional tort, and I'll explain what that means. Two is negligence, or an unintentional, it doesn't require an intention. The third is strict liability. So what's an intentional tort? Let's say you were at a bar and somebody sued you and said you hit them. You literally went up and just knocked them in the face. Well, plaintiff would have to show that you intended to hit him or her. You intended to hit him or her. Let's say on a defense, you were able to prove that at that moment that you hit the person, you had a stroke, and your arm went out and punched the person, but it was due to a stroke. Would you be liable? The answer is you would not be liable. And the reason why you would not be liable is because of the fact that battery, which is an intentional tort, requires the intention to hit the person. And a stroke, essentially where you're flailing your arms up in the air, that's not an intention to hit somebody. What is negligence? Negligence is where society has set a standard and you fall below that standard. Let's pretend that you have two cars. You are in the back and the car in the front stops. Not fraudulently, just stops at a red light. Boom, you hit them. This morning, that almost happened to me. Who is liable? The car in the front or the car in the back? Obviously, the car in the back. And the reason why is society has said that when you are at a red light and the car in the front has stopped at the red light, not fraudulently, just stopped, the car in the back has a duty to the car in the front. So that's the reason why the car in the back is liable. The third type of tort, non-contract civil claim, is strict liability. I have two dogs. My first dog is a Yorkie, very small. Nobody wanted him. His name is Pee-Pee. I have another dog. He's a stray. His name is Boo Boo. Both of them super cute. If one of those dogs went up and bit somebody, who is liable? I'm liable. Why am I liable? Because of the fact that if it happens, you are liable. And that is strict liability. Now, why is this important? Why am I spending 2-3 minutes to talk about this? Well, the reason why is because when you go to an attorney for a civil claim, in his mind or her mind, they have civil claims split into contracts and torts. And torts are split into whether you require an intention, whether there is a duty, or whether it is strict liability. So therefore, this is 1 year of law school where you can be able to go to a law firm, speak to an attorney, and know what the attorney is thinking about. Now, are there a lot of lawsuits in the US? Yes. I just want to tell you that federal court, 282,895 in 2010. Last time I checked, at the end of 2017, it went up to 374,293. In California, it was 1.2 million cases in 2009. And in 2017, it went to 6.2. Obviously, there are many more lawsuits in 2022, and a majority of the cases are employment. But there are a lot of lawsuits in California, and therefore it's good that we're lecturing today and speaking today. Here, this is not where I'm going to spend a lot of time, but I've used this chart to explain the real estate purchase and sale. For those of you on your phone, just to let you know, I will have the PowerPoint sent out to everybody so that they have it. And basically, it just talks about the process of the real estate transaction. So very quickly, realtor meets buyer, lender pre-qualifies buyer. If they're unable to qualify, you develop an action plan. Then you have a pre-qualified letter issued. Then the buyer goes shopping with the realtor. An offer is made. If the offer is not accepted, then there's a counter offer. If the offer is accepted, then you open title. If the offer is not accepted, again, you have a counter offer. And then once you open title, then you open escrow, and then you have a loan underwriting. All of these things I think are helpful. And a lot of real estate agents have told me that this is very helpful to be able to explain it to their client. Again, once you have title, there's the loan underwriting on the right side, title in the middle, escrow on the left, everything gets done. And then you have the title recorded with the county. Congratulations, you have a new home. So a lot of people like this chart. They come to the lecture, I think, merely for this chart. I don't know if that's good or bad, but this is the chart that I've used to explain to my clients during the litigation process. Actually, we use this chart quite a bit to kind of explain how things are done. I think this is really going to be able to help you. Now, before we go to the 2022, wow, I mean, I'm still thinking we're at 2020, but we're now at 2022, new laws. I'm going to talk about lawsuits that I typically see among agents and buyers and sellers. Now, I haven't talked about agent commissions, but I do want you to know that a lot of agents are leaving money on the table. Very quickly, because it just kind of came to me, that if you bring a prospective buyer and it's within the realm of reasonable possibility of the pricing range based upon the comparables, and a seller rejects it, etc., you are entitled to your commission. But that's a totally different discussion. It takes me about half an hour to get through, but it just came to me as I was speaking. I'm seeing a lot more of the agency commission lawsuits coming up. But last year, these are the things that I saw. People that can't read English. Basically, I've seen a lot of these type of lawsuits. Yes, in California, there is something called mutual consent. So mutual consent requires two people to consent on the same thing, because if you consent on the same thing, then that's a contract, right? So, a lot of times attorneys like to say offer, acceptance, consideration, etc. But a lot of people don't talk about mutual assent. Both parties have to agree to the same thing. So yes, in California, there is mutual consent, but I do want to write out here Civil Code 1556 that says all persons are capable of contracting except for minors, people of unsound mind, or person deprived of civil rights. When you read Civil Code 1556, does it say people that cannot read English? And the answer is no. In the real estate context, many people use the excuse of unable to read English to try to get out of their agreements. And a majority of California law, unless it's based on fraud, a majority of California law has said, if you sign it, then you agree to it, whether or not you read English. Now, this is in the real estate context. This is a little bit different in the employment context. And I'm not going to go into the employment context today, although I do have some employment laws that I think are very important in the real estate industry. But the recommendation to the broker is you should always remind the client that you are not interpreting for them. A lot of times, real estate agents and brokers get into trouble because they become an interpreter. And if you become an interpreter, then there's a duty as an interpreter, and it goes outside of your expertise. So you should always let the client know you can't interpret it for them in Chinese, because I'm Chinese, so you can't interpret it into a foreign language. You recommend them to hire a translator. And in fact, on larger transactions, typically commercial, I recommend my client to translate the agreement into the language that they understand. Now, I speak Chinese. My Chinese, I would say, is probably at if you speak to my clients, they say, I'm very good, but yeah, I'm very good on legal terms. But I would say that I'm probably at an elementary to junior high level. Outside of the legal context, you would think that I was an idiot. And I think many times when I speak in Mandarin, I just sound so bad. But in that context, I always recommend my clients hire a translator, go out and get it translated for a contract or for a transaction that costs $10 million. Why aren't you having the client spend $2,000 or $3,000? It doesn't have to be certified translation. Have them translated into a language they understand, so this issue doesn't come up. This issue doesn't come up because I've seen a lot of these lawsuits in the last 2 years. The second issue I want to remind everybody is that you are not an attorney. And because you are not an attorney, there is no attorney-client privilege. Now, here's the funny thing. Many people, particularly from a foreign country, they tell their CPA that they want to hide money. They tell their CPA that they don't want to pay taxes. They tell their real estate agent all of their little secrets. And what ends up happening to the real estate agent? They get brought into a lawsuit, whether as a witness or whether as a person that is liable to the buyer or the seller, one of the parties. So it's better for you just to remind the client, I am not an attorney. Anything you tell me, if I'm called, I have to disclose it. My solution typically is that I recommend that if there's something really private that you want to do, you can have a law firm hire the CPA. So the CPA is part of the law practice, hire the real estate agent, so they're part of the law practice. So it does fall under the umbrella of the attorney-client privilege. Sometimes some clients are unwilling to work with you if you do not have this confidentiality that ends up occurring. And the problem is a lot of real estate people, because you are representing your client, you believe that there is confidentiality and you tell your client, well, whatever you tell me, don't worry, I won't tell the other side. And I understand that this is negotiation, but when there's litigation, all of the statements that are made by your client to you must come out from you. Another one is oral promises. And this is a problem that I've seen a lot in the last 2 years. There are a lot of lawsuits related to oral promises. You do need to remind the client that in the real estate context, almost all real estate contracts I see waive any type of oral promise, any type of oral promise. In fact, many of the contracts I see say that any prior agreements, even if they're written, are no longer valid. Now, why is that important to you in the real estate context? Well, a lot of times contracts are signed at different times. If you do have an agreement, let's say at the very end, that says all of the prior contracts are invalid, all of the old ones, whether written or oral, etc., are gone, then that means that the last contract you sign is the contract that's binding. And I've had a lot of real estate agents, brokers, loan people in loan, etc., escrow people have gotten in trouble because of that, because they look at everything as boilerplate and they don't realize that at the end of the day, a judge is going to take the words on the paper at face value. And if the words on the paper say there is nothing else, then that is going to eliminate all the prior agreements, whether oral or written. So I provided an example that I see quite a bit. And this says, this agreement, together with the other loan documents as written, represent the final agreement among agent, lenders, and borrowers, and may not be contradicted by evidence of prior, contemporaneous, or subsequent oral agreements of the party. There are no unwritten oral agreements among agent, lenders, and borrowers. Now, this is just for the oral side, but you also see this in regard to, you just change it a little bit. So instead of the oral, you just said that there are no other agreements, period. And I see that a lot. So please be careful for this specific section of any agreement that you read if you have any other prior agreements, whether oral or written. Another thing that I've seen is the failure to disclose. And I have seen less of this recently, but I included this because 2022, 2023 in particular, I'm going to see a lot of lawsuits related to this issue. And that is that the seller does not disclose known defects. This should be to the buyer. I apologize. That's a typo. I haven't had time to review the PowerPoint, but that is a typo. So seller must disclose any known defects to the buyer. If the seller does not, the seller, it's not could be, should be held responsible for failing to disclose defects. Now, why do I see a lot of people getting in trouble? The answer is sellers right now are doing what's called as is. So an as is basically means you take all of the defects, period. And the buyer says, wow, there are 20 other buyers for this property. Of course I am. Here is the problem. California, as is very different from other states. California says, if you know of a defect and it is not easy, you can't easily find it, meaning that the roof has a hole. It's not a hole that everybody can see. And you know that that hole has caused water damage in the property. And you don't disclose it to the buyer. Even if you sell it as is, you will be liable. Well, guess what? Why do agents get in trouble? Because the sellers told the agent, and the agent said, don't worry about it. We're going to do it as is because we're going to sell it for the highest possible price. Big problems. Another issue I have is agents not explaining escrow instructions. Now, you have to understand, California is much different from other states, much different from the East Coast. So on the East Coast, purchase and sales are done by real estate attorneys. In California, attorneys are able to do real estate transactions. They don't need escrow. However, attorneys are usually more expensive, and therefore escrows have been created to facilitate real estate transactions. Here's another typo. I'm not happy with typos. I apologize for that. Feel a little bit thrown off. Escrows are only allowed to follow the instructions of the parties and nothing more. When there's a dispute, escrow will do nothing until the dispute resolves or deposit the money with the court. Why is this important? Because a lot of times agents don't tell the client, please, 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 please understand, yes, you have a purchase and sale agreement, but your agreement is the purchase and sale agreement, the P&A, and the escrow instructions. If there is something in the escrow instructions that essentially when there's a dispute or you don't like the term, you can change it. I understand that escrow instructions feel like they're boilerplate, but I think when you read it closely, particularly if you have an escrow company that you work with, sit down with them and ask them, hey, what happens when there's a dispute? You're going to realize that it's not always the way the parties think, and it's not the way the agent thinks. So escrow instructions, it's easy to change them. Escrow will easily change them for you, even though they're going to give you a hard time. But you have to remember that the escrow instructions form the basis of how the money is held. And the escrow instructions typically are, we're going to hold them until the dispute ends, or we're going to deposit the money in the court. And a lot of times, buyers and sellers, particularly in regard to the deposit, the good earnest money, they get into fights. And if it's $10,000, $15,000, $20,000, it's not bad. But I've seen escrows hold hundreds of thousands of dollars to millions of dollars, and everybody's upset. Everyone is upset. This one's a little bit harder to explain, but regarding title insurance, I just want to say that title insurance you're going to obtain on most transactions of real estate, but I do want you to know that if you are confused between CLTA and ALTA, just pick ALTA. How do you remember that? A stands for America, C stands for California. Is that what it stands for? Probably not. But the way I explain it to my clients is just go ALTA. Just remember, A is for America, C is for California. America is bigger than California. Another one is the title insurance exclusions and exceptions. The problem that I find is that, particularly with insurance, so title insurance is an insurance. You have to understand that title insurance is going to cover you, but it's not going to cover you if it falls under an exclusion or an exception. And what that means is we're going to cover you for a million things, but we're not going to cover you for certain things. Now, why is that important? Most agents, when they're talking to the client, although I don't recommend it, that they're giving legal advice, but look, in my opinion, real estate agents is the most amazing profession because there are two things that people love. One, they love their children. Two, they love their property. Why? Because typically, if you're able to be involved in the first purchase of a home, they share with you everything. Recently, someone shared with me that she lives right now in Arcadia in a beautiful home. And she told me that her mom was actually a maid for one of the mayors of Arcadia. And her dream in life was to live in Arcadia. How beautiful is that? Well, the beauty of that is that you have a personal relationship with these people. And because you have a personal relationship, they're going to be asking you to do a lot. Not just, hey, my toilet doesn't work. What's going on? Do you know a good lawyer? Do you know this? Do you know that? Do you know a good divorce attorney? What ends up happening is you do end up having, which isn't good, but you do end up having a relationship where you have to explain things. And they're going to ask you, what is title? And title is basically an insurance in case something goes wrong in the house. But the problem is that most agents focus on what is covered. They don't focus on what is not covered. Not covered. So I'll give you an example of things that are not covered in one of the contracts that I was reading. Matters arising after the effective date of the policy. Let's say the policy was March 1st, and then the city put a lien on the property on March 10th, and the transaction completed on June 31st. Guess what? Title says, I'm sorry. Matters created, suffered, or assumed by the insured. Matters known by the insured as of the date of the policy, but was not disclosed to the title company. Title says, I'm sorry. Violations of zoning or environmental protection laws. I mean, you would imagine that, let's just say that you purchased a home, like an apartment complex, and the next thing you know, the city comes to you and says, hey, you're not supposed to have this apartment building here. You're in the wrong zone. You would imagine, but I bought fee simple. I bought the apartment building. What's going on? Well, the title insurance here says if there's a zoning violation, we don't cover it. Claims based on the transaction creating the insured interest being deemed a fraudulent conveyance or preferential transfer. What does that mean? Let's just say that Bernie Madoff transferred money and purchased a home, and then that person subsequently sold to you. And the next thing you know, you thought you bought a beautiful home, but then suddenly the SEC is suing you. You're going to say, wait a minute, this apartment building belongs to me, or this house belongs to me. Title insurance, you better cover me. And guess what? Title insurance for this specific This specific contract is going to say, sorry, it was a fraudulent conveyance. I can't do it. I can't cover you. So this is very important for agents to understand, is that title insurance is great. You obviously are encouraged to get it. You're encouraged to get ALTA, not CLTA, but again, not everything is covered. Another issue that I have found very strange is that agents should know this, but for some reason, I don't know if it's a loophole or if they're just not disclosing it over to the client. But what ends up happening is that because clients outside of the US, notaries are directly from the court. So notaries are different from the court. This is particularly in South America, Latin American countries, but Asian countries and European countries, the notaries also have, in many countries, judicial power. So what does that mean? They feel that if something is signed and a notary stamps it, then it's given extra power or extra weight. The answer is that's not true. So we want to be very careful, if you're an agent, not to manipulate the minds of your client, because you have to explain this to them. I had a lawsuit over this issue, so that's why I included. Elder abuse. I have had agents get in trouble for elder abuse. There are agents that are really smart. They go to all the elders in the community. That's their niche. They know how to speak to people over 65. They know what to say to somebody over 65. They do all of these transactions. And the elders typically don't really push back. Some of them do, but a lot of them don't. And what ends up happening? Well, their family finds out about it and they sue the agent. Why? Why did they sue the agent? They sue the agent because the price wasn't sold correctly. Why is that important? It's important because of the fact that the elder abuse statute is written so broadly in the state of California that basically the standard is the way you treat an elder over 65, if a reasonable person would not have done it, you're liable. What's a reasonable person? It's so broad. Well, I'll give you one of the examples, and when I read it to you, I think you'll be kind of scared as well. And that is Welfare and Institutions Code 15610.30b. It states that a person or entity shall be deemed to have taken, secreted, appropriated, obtained, or retained property for a wrongful use. Basically, a person that does this is wrong. If, and I'll read it at the very bottom, I don't mean to skip, if the person or entity knew or should have known that the conduct is likely to be harmful. Likely to be harmful. So let's just say you sold it for $100,000 less. Can you be able to say, hey, that's the market. That's what the seller was selling it for. If that person is over 65, then they can be able to sue you and say, you know what? It was likely to be harmful. You shouldn't have done it. I'm going to overturn the transaction, or I'm going to ask the real estate agent for my $100,000 back. Very, very scary. I've seen a lot of lawsuits like this. Please be careful, because I'm seeing agents fall into this trap. There's right now, everybody, because the real estate market is very competitive. And I do want to say that, yes, every time we go to a real estate meeting, the real estate agent that gets up says, I did $10 million, I did $15 million, I did $100 million. But the reality is the average real estate agent, really, it's a very competitive market, isn't doing as well as everybody says. It's like that with every market. And real estate agents now have begun to ask themselves, how do I niche myself? And there are a lot of real estate agents realizing that the elders are a great business. And I agree. Because in Arcadia, for example, somebody has purchased a home for $30,000 or $40,000. That's very typical in Arcadia. Their home now is worth $2 million. An elder is going to say, wow, $2 million. But what about if that home is worth $2.5 million? And the elder says, yeah, $2 million's great, right? I bought it for $40,000. And that makes sense to you. The problem is that under Welfare and Institutions Code, if it is likely to be harmful, you could be locked in an elder abuse lawsuit. Are we doing okay? I actually feel like I'm like so dry and boring. Sorry. Boy, if I feel that way, I can't imagine how everybody feels in this Zoom universe that we're in. So I apologize. Issue number 8 talks about forgery. And what forgery basically is that a lot of people, if you live in a foreign country, will tell the agent, hey, look, just sign for me, right? Just sign for me. But they don't get a power of attorney. And eventually what ends up happening is that the agent gets sued. I see this a lot. And I really don't know why I see this a lot, but I've seen this a lot. And so it's improper and illegal to sign for someone else without a proper power of attorney. The proper power of attorney, it's a simple form. Yes, you do get it notarized. I do want you to know, whether you believe it or not, that it's very easy to get a notary outside of the country, because most US embassies so far, all the US embassies that I know, have a notary at the US embassy. So don't tell, if the client comes to you and says, oh my God, I can't get a notary, I don't know how to do it, China is so big. Yes, China is very big, but you know what? They can travel, they're 2 to 3 or 4 or 5 hours, and they can go to a notary and they can get this done. Escrow also has generic forms for you to use. I'm trying to get excited. I am so exhausted, and I apologize for being exhausted. You guys are the best group. Maybe it's because I'm not in front of you guys. So, letter of intent. The letter of intent is, there are more and more letter of intent litigation that I see. And I want you to know that a lot of people don't understand what a letter of intent is. Everybody thinks it's the first one. It's the first one. A non-binding letter of intent basically means when there is no agreement, there is no obligation. Simple. The problem is this. Many attorneys know this, but non-attorneys don't. So I want to make sure that you know about it going into 2022, because I've seen a lot of these lawsuits. A binding letter of intent says that when there is no agreement, this document is binding. How crazy is that? So when you see binding letter of intent, you're like, oh, well, yeah, it's a letter of intent. Not a worry. You tell the client, don't worry about it. We're just negotiating back and forth. It's just negotiating. Well, then someone comes to you and sues you. They say, hey, I have a binding letter of intent. There was no agreement. Pay up. I sue you. And you're like, but I don't understand. And of course, your client says, well, I don't understand either. This is what my agent says. My agent committed negligence, and then they sue you. And then the agent says, well, that's outside of my expertise. I didn't know, right? And therefore, I have no negligence. I disagree. So the binding letter of intent means that when there is no agreement, the document that just says letter of intent, that is binding. Be careful, because it's usually buried in the agreement. Attorneys don't use the word hybrid, but you have to be very careful. And that says, if there is a future agreement, the terms that are in the letter of intent must be included and cannot be contradicted. Again, you sign a letter of intent. The letter of intent says these terms are going to be in a future agreement and will be used and cannot be contradicted. Everybody's like, oh, okay, whatever, right? The problem is that in that type of situation, when you write that type of situation in, or that type of clause in, it could be deemed as, if there is a future agreement, these terms must be included no matter what. Just very quickly, just to end, not end the lecture, although I'm sure everybody feels that way, is these are typical contract provisions that I think you need to be careful of. This one, attorney fees, in the real estate context, so everyone outside of the US believes that if you lose, you have to pay. However, there are certain laws in the US where sometimes you have to pay and sometimes you don't. Well, the law basically says that when the attorney fees provision is not written in there, that says whoever loses has to pay, then there is no attorney fees if you win. So just very quickly, just to let everybody know, venue is very important because I do see contracts that are written up in regard to venue where they don't really say where, if there is a dispute, where are they going to litigate it? You have a New York buyer, California seller whose property is in Texas, money transferred from Shanghai. Where do you litigate it? In terms of the venue, whose law applies? That's also a possible venue issue. And so be very careful. And the reason why is a lot of real estate agents are not merely working with purchase, sale agreement, and escrow and title. They're working with a lot of other agreements on the side, right? I know it sounds bad, but that does happen. So just be careful. Foreign contracts are actually okay. So you can have foreign contracts that are incorporated into your purchase and sale and incorporated into the escrow instructions. But don't forget, California law always applies. California law always applies. So if you have a Chinese agreement, totally okay. If you have a foreign language agreement, totally okay. The problem is it still has to comply with California law. Who are the parties? That's very important because a lot of times I see two parties and it's corporations or one individual and one corporation, and a person signs. Although it's a corporation, usually your client may feel that the person signing is personally liable. That's not true. It's very excuse me. It's very difficult to get personal liability. So if you want personal liability, you have to have them as one of the parties. And hence, number 5, no personal liability of individuals if it's corporation signing. The last one is arbitration. This is in many real estate contracts, but there are a lot of people that don't quite understand arbitration, or they may understand arbitration from the context of their own country. And you need to explain it to them or have an attorney explain it to them. Again, I recommend the attorney explaining it. So here's a bonus tip. I was kind of thinking about you guys, just thinking in general, before we kind of get into 2022. And one thing that I want to say is that many times I see a client and the client has 5 years of facts, really, 10,000 documents, 5 years of facts. And they come to you and they say, hey, I would like a legal opinion. Here's my 2-minute, we're having a glass of wine. Tell me what you think. I don't think that's a great way to get a legal opinion. It's a very poor way to actually get a legal opinion. And so this is what I recommend you do if you are going to meet an attorney. The first thing, take 3 pages, just 3 pieces of paper. On the first page, you're going to write what happened. What happened? On the second page, you're going to write what you want. What you want. And the third page, you're going to write what the other side is going to respond to regarding what you want. Now, why is this important? Those are really the 3 things that an attorney is going to consider. What happened? What do you want? And the bad facts. The bad facts. You don't have to know the law. Why is this important? I talked about having a glass of wine, but I'm going to talk about what ends up happening when a client comes to an attorney's law office. The client is usually very disorganized. They don't have a timeline. Everything is messed up in their head. And the attorney, just like earlier, I was saying, man, I feel so bad for everybody. There are people on this call, this Zoom lecture, already zoned out within a minute, 2 minutes, 5 minutes, where they're going to come back. Well, guess what? Attorneys are the same way. They're not focused 24 hours a day. We use our brain all the time, but we can't be focused on you. So if you aren't able to articulate well within 5 minutes, pretty much the attorney is gone. He's thinking about another case. He's thinking about city council meeting. He's thinking about a whole bunch of stuff. So if you're able to write down what happened, what do you want, what the other side is going to say about what you want, send it to the attorney early. Send it to the attorney early. Give it to the attorney so that the attorney can be able to review it. Now, what is the attorney going to do? First thing the attorney is going to do is he's not going to review it. and he's going to meet you, he's not going to know what happened. Great. Didn't want to hire the attorney anyway. It's great. Second thing is the attorney's going to look at it and be like, wow, this is a, I don't know, a family law case. I don't do family law. And he's going to refer it to someone that does family law, because referrals are the best way to get clients. That's great. That's great. You didn't waste your time. You got a good referral. The third thing that the attorney is going to do is the attorney is going to read your paper. Now, why should it be limited to one page? Because again, you only got 5 minutes to speak to the attorney. One page, it's about 5 minutes. Good way to be able to articulate everything on one page. If you can't articulate everything on one page, not a good sign for you. Second thing attorney is going to do is he's going to know what you want. Let's say you got into a car accident. You want $10 million. Attorney is going to tell you, I can't get you $10 million. Attorney will probably even tell you in advance, I can't get you $10 million. Isn't that a good thing? Isn't that a good thing? Because a lot of times you go, clients come in and I say, what do you want? They didn't send me the 3 pages. And client says, I don't know what I want. You're the attorney, you should know. Very, very bad move. The third one is, if you tell the attorney what are the bad facts, the attorney then can be able to give you a good assessment. If you do all of this, give it to the attorney in advance, you will find a very productive meeting. You're going to walk out of that meeting and be like, wow, I learned. 90% of people that I meet when they speak to attorneys, they really feel that the attorney talks over them, right? Like when you go to the doctor and the doctor is just mumbling all these medical words, you want the doctor to slow down. Whoa, 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 right? I don't understand. Well, the attorney really in many ways is the same way. The flip side of that is the attorney doesn't even know what happened, doesn't know what you want or what the other side is going to say. And he's just going to slap his hand on the table and say, that's the most ridiculous case I've ever heard. We're going to take him out, right? And you're like, wow, this attorney's really good. But he still doesn't know what your case is about. This is going to help him know or her know what happened, what you want, and the bad facts. I just looked up and I realized we need to move forward. Photocopy all of your documents, please, please, because there's been a study that 5% of documents are actually lost. 5% of documents are actually lost in the middle of litigation. It's crazy to hear, but with all the documents and the scanning that occurs, not every machine is perfect. Photocopy all of your documents. I would prefer give photocopies of the documents to your attorney. Give the photocopy unless the attorney wants the original. The last tip I'm going to give you is going to make you a superstar, and that is an Excel spreadsheet. Excel spreadsheet. This is what ends up happening when you're in the middle of litigation. Hey, attorney, how are you? Wait, I don't understand. Like, of course you should know. Of course you should know. I emailed you. What does that mean? It's very hard. Many times I have found, and I'm speaking really on behalf of attorneys, attorneys are scared to tell their clients, I don't know what you're referring to. I don't remember. Because clients feel that attorneys only have one case, their case, but the attorney has lots of cases, right? They either have few cases, super deep information, or they have many cases, deep information across many cases. And attorneys are scared to tell their clients that they don't know what document they're referring to. Well, guess what? Guess what? If you do this, you will be able to help your attorney. If you do an Excel spreadsheet and you have the documents, so the top is the document number. It's not one, it's just document number. The 2 is that you name the document. You don't have to be an attorney to do this. You have to remember, attorneys didn't go to law school to be secretaries. Very important. The third one is what does it show? And the fourth one is why is it important? So for example, document number 1 has 12 pages, 1-1 to 1-12, 12 pages. Every page on the bottom says 1-1, 1-2, 1-3, 1-4. And then the second one, the Excel spreadsheet, this is the contract between the parties. Just give it a name, any name. The third one is what does it show? The fourth one is why is it important? Sometimes what it shows and why is it important, I understand it kind of blends together. Now, why is this important to you? So like exhibit 2 has 4 pages. It's an email between the parties. It shows that he admitted that he did wrong. And it's important because he says that we do not have any correspondence between us. Why is this important? When you speak to your attorney, you're no longer speaking to your attorney by saying, I emailed you, I told you. You just tell your attorney, no problem. Please go to 1-3, please go to 2-4, and everybody now has the same information. And the attorney has an Excel spreadsheet telling the attorney what does it show and why is it important. Okay, it's already 11:50. So very quickly, 2022, AB 1466 requires a title company during the transfer to identify whether any of the documents contain unlawfully restricted covenants beginning July 1st, 2022. This is actually going to cause many title companies to slow down. What this basically was made to do is, believe it or not, the purpose of the law was unlawful covenants many times. So I'll give you an example. Many of the cities in our area, Arcadia, South Pasadena, etc., were sundown towns. And what a sundown town basically is when the sun goes down and you're not a specific race, you're not allowed to be on the street. Pretty crazy, but there's a lot of property documents that have statements in there that are also improper. So I had a person come up to me in Arcadia that's Latino that basically said when he first came to Arcadia, he had to say that he was Italian. And if he didn't say he was Italian, he was unable to purchase property. Well, if the property documents have these things in there, well, they need to be removed. And that is one of the rules of AB 1466. So that's starting pretty soon. This one is actually pretty big that I want to tell everybody about. Is there are two issues that are very important. It's an ADU plus a lot split, ADU plus a lot split. So the ADU is law that's already been passed. A lot split allows one property to be split into two different lots. The laws that you need to read are SB 9, SB 10, AB 68, AB 345, AB 591, AB 1584. The way you look for it is the first link. Just type it in. The second issue is in regard to affordable housing. Now, if you look here, you'll see Arcadia. I'm not saying this because I'm part of Arcadia, but Arcadia has really good staff reports. So what is a staff report? Now, this is something that I think can really help you, is that before something goes to city council, we are required to have a staff report. And a staff report explains what we're going to be making a decision on. Why is that important? Well, if you get a city like Arcadia who has really good staff reports, that's much better than going to Google. I'm going to say it again. Please do not Google. I find Google to be really bad. But if you go to a city, particularly the city that you have a transaction in, and you just type in what you want, the staff report that pops out, it is great because the staff report are written for non-experts, and the non-expert is a resident. And believe it or not, city council members are non-experts and they are just residents. So please consider doing this. So affordable housing, if you click on this, I'm not going to click on it now, I don't have time. I was planning to, I didn't realize I was running out of time, is that you will go to this and when you read it, you're going to be like, whoa, your whole mind is going to just boom, right? It's going to be incredible. Okay. ADU summary very quickly is that ADU is called an accessory dwelling unit. A JADU is called a junior ADU. So typically an ADU, if you think about it, is you have a property, ADU is outside of your property. You're just going to build something outside of your property. That's ADU, but it's on your property. A JADU, the way you think about it, is just inside your property. JADU is inside your property, ADU is outside of your property. So the ADU and JADU timeframes, super fast, meaning that cities pretty much have to rubber stamp it. So if the cities do not act, they are automatically granted. ADU and junior ADU can occur on most residential lots. And the argument is that on one lot, you can create a triplex. And that's what you need to kind of know about the ADU process. In terms of the lot split for 2022, super important. That's really based upon the SB9. So the 2-unit residential development, so it's basically a 2-unit residential development on any zone lot, regardless of size, right? That's going to be in the ADU context. Setbacks are basically eliminated. 1 parking space per unit can be requested by the city, not necessarily a requirement. Not, but not. See these typos, killing me. Subdivisions must be rubber stamped, provided that the split results in a division of no less than 1,200 square feet and not less than 40% of the original footprint. Where do you go? Arcadia staff. They are the best. So Arcadia staff has a total deep explanation on the SB9 process. However, cities are fighting back. So why is that important for you to know? Because in 2022, everybody thinks lot splits, super easy. The answer is super easy, not necessarily beneficial. So cities are in a panic because they want to preserve single-family residence zones. As such, many have enacted emergency ordinances to make it cost ineffective for property owners that want a lot split. So for example, Arcadia is limiting the new units on a lot split to 800 square feet. It effectively kills most of the lot splits. That's the effective result. Again, I'm not speaking from the city councilman's standpoint, so please understand I'm speaking about it from the attorney's standpoint, right? Is that the decision of city council was to fight back to, within the law, craft a law that essentially makes it not advantageous for people to do lot splits. Now, why is that important to you? Is because when you're doing a lot split, my recommendation is that you need to do the following. For ADU and lot splits, here is my recommendation. Do not go online. Do not go online. Go to the city website that you have the property in. Type in SB9, type in ADU, and you're going to find an agenda item. And the agenda item is going to explain to you and the rest of the world in plain English without any advertisements, right? It's not the attorney advertisement. It's not, I can do the ADU for you. It basically just says, this is what the ADU is, or this is what the JADU is, or this is what the lot split is. This is how we're going to do it. This is how we're resolving it. Now, why is it important? Once you read the agenda, then you can make an appointment with staff after you've read the agenda. If you find the agenda is not written very well, go to Arcadia. Arcadia has great staff reports, all right? And also understand that cities are fighting back on the lot splits. So the last thing that you want is for you not to understand that the city maybe has limited it to 800 square feet, and you're gonna have all of these issues. Affordable housing, every 8 years, every city is required to do affordable housing. I don't have time, I only have 2 minutes left, but basically in terms of affordable housing there's something called RENA, and RENA basically says that within the next 8 years, the city is supposed to target specific pockets of the city to build affordable housing. It's a promise made from a city to California, the state of California, to achieve a RENA number. Why is that important to you in 2022? Because this is a new law. Cities are required to get this done. Many cities are finalizing it, but this is really going to help you. So in Arcadia, we have to build 3,214 housing units under the RENA. Also understand, for those of you that are developing, there are things called density bonuses. Density bonuses, meaning that if you allow for affordable housing, they will actually allow you to have more units. And sometimes you get government benefits to offset it. Here's an excellent summary by the city of Arcadia regarding affordable housing and RENA. I don't think this talks about density bonuses though. Very quickly, COVID relief. This is the COVID relief. I've cited the statute so you can read it on your own. again, speak to David Ching or Joseph Castro. If you're talking about at my office, you could just give them a call in regard to COVID relief, real estate evictions, etc. Unfortunately, I'm in trial and I'm just not thinking about evictions right now. CFRA, this is employment, but this really impacts a lot of real estate companies. Please read this, because if you don't read this, it's going to be a big problem. Settlement agreements, you can no longer settle claims in settlement agreements. That prevents a person from talking about discrimination, a protected class, their problems. So I just want to put that in there, because a lot of real estate, we do have a lot of people that are in real estate that are owners that have this problem right now. And sorry, this 1 of 2 is a typo. It was actually just 1 of 1. Wage theft, please be careful. A lot of people that are coming in into the US are opening up businesses. You as a real estate agent are working with them. Understand that there is now a penal code in the state of California that basically says that if you are part of any entity that hires an employee and you owe them over $950 for 1 employee or $2,350 for 2 or more employees, it is now criminal. Be careful. Independent contractors, please continue to fill out the DE 542. A lot of real estate brokers are not filling this out for their independent contractor agents. Please do that, because they're being audited. I've seen this quite a bit. And I do see that if you have an illegal workers' compensation, meaning that you have employees that should be employees, but you put them as independent contractors, there is now, it's criminal. This statute has been in place for a while, but I have seen this enforcement starting to occur quite a bit. It is now 12:02. Now here is my recommendation. If I could have the staff email, oh, hey, Nancy. Oh my gosh, Nancy, oh my gosh. Thank goodness I did not see Nancy Chang, because I would be so nervous. She is like, she walks on water. And I have to say that it is an honor to have Nancy Chan here. Now I'm nervous. So with that being said, my recommendation would be this. Instead of having random questions come in, and I know it's already 12:02, is that I would take the questions, I would provide a substantive, a more detailed answer, email it back to the team so they could distribute it out. And if anybody has any additional questions, they could email it to the West San Gabriel Valley Realtors so we can have the questions. I see a chat of 6. What do you think about? Okay, this is great. So only 2 questions. Oh, Mindy Ye's here. Oh, wow. Everybody's here. Geez. Okay. So Pauline's here. All right. So with that being said, these questions are actually really easy, meaning that it's not good. I would like everybody, they've listened to everything, take a step back, email your questions in, have the team email it over to me. I'm going to be able to then put it together in a very detailed format, send it back over to you so you can distribute it out with the PowerPoint if I have time to correct the typos. There aren't too many typos, but I would like to correct them. If we could be able to do that, that is great. I wanted to lastly say thank you so much for everybody that is part of the real estate transaction. It is the most incredible transaction. I remember purchasing my first home and just seeing my wife light up. That's something that I think will never go away. And I just wanted to say thank you. You are making not just the American dream come true, but just dreams come true. Because life is just about memories. You look back and all you think about are just your memories. And I can be able to guarantee you one of the memories, one of the biggest memories, apart from having a kid, although I haven't had a kid, but everybody tells me it's wonderful, is when you purchase your first home. Thank you very much. God bless you. Have a good day. And thank you for your support. Thank you.
All right. That concludes the presentation. Thank you so much again Paul. On behalf of the West San Gabriel Valley Realtors, we would like to thank Paul for being our guest speaker and for your informative presentation today. Please check out our website for our upcoming classes, and we hope to see you there. Till then, goodbye.
Bye.